Happy Monday afternoon, everybody. Happy Labor Day. I am your host, Shad Dales, and thanks for checking into our TDR Trade to Black podcast. It's been about a week since the DEA made their announcement about the ALJ hearing, which will now take place, as we all know, on December 2nd after the U.S. federal election. We've had a lot of speculation on what we can think as far as timeline, but we want to bring in one of the most sophisticated cannabis lawyers in the country that can give us an understanding of the roadmap that lies ahead and what we can expect next. So with that, let's welcome in TDR co-host Anthony Varell. Happy Monday afternoon. Happy Labor Day. How are things?
Happy Monday. It's good. It's nice, relaxing weekend so far. I know we got the rest of the week in Vancouver. This will be a good conversation. I mean, Eric was one of the authorities on leading into this, and now this curveball that we got hit with last week, which some might not say was a curveball. I mean, it'll be good to get clarity and his opinion on the matter.
Yeah. With that, let's bring in Eric Berlin from Dentons back to the podcast. Happy Monday afternoon. How are you, sir? Good to see you.
I am good, Chad, Anthony. Nice to see both of you. I hope you had a good weekend and proof that cannabis lawyers labor even on holidays. So good to talk to you. And this is obviously an important development and worth making sure folks have the right facts on. So very pleased to be on the show.
That's exactly why we want to have this conversation, to find out what's next. We all know. The DEA came out, basically made the announcement that this hearing, I was surprised to see it pushed all the way back to December 2nd. So the first question I have, why was it pushed back that far? Why do you not think, people can say, yes, there's a U.S. election going on, but were you surprised it was pushed back as much as a little over 3 months?
So I don't know if surprised. I mean, I spent a large part of my career as a litigator, and I know that here in the United States, the wheels of justice turn slowly, and it just takes time. So that could have just been a logistical issue. It also, once you set a hearing, you need to give folks time to make requests to appear at the hearing.
Okay, let me go one step further. Do you think it was necessary?
So let me say this, and I appreciate you asking that. I think the hearing itself is unnecessary. And I'm not questioning the judgment of Administrator Ann Milgram, and there may be dynamics and there are good reasons to hold this. But just from my perspective, I think it's unnecessary. You have the FDA's really well-supported 250-page report that outlines the currently accepted medical uses for cannabis, and that it clearly has lower risks of harm or abuse than a Schedule 1 or 2 drug. And then the Attorney General here was so careful as to bring that standard before the Office of Legal Counsel. And the ALC advised the DEA that the FDA's analysis, and particularly that standard for currently accepted medical use, was appropriate. And in fact, went back and said the DEA's previous 5-part test was impermissibly narrow. And so this comes into the DEA under the Attorney General very buttoned up. And the OLC also said to the DEA, you must defer to the FDA's scientific judgment. You might disagree, but that doesn't matter because legally you have to defer to it. It's also, so, I mean, there's a record of all of that plus 40,000 comments. Now, not all 40,000 are substantively helpful, but what I'm suggesting is the record is sufficiently complete here. I don't think there's a need for the additional counsel or additional hearing. In addition, the rescheduling would not legalize cannabis or the state programs. And the hearing notice itself makes a big deal about this, right? It says the transfer to Schedule 3, if finalized, wouldn't legalize the substance. And you'd still have all the requirements and additional controls, and the manufacturer distribution, dispensing, and possession of marijuana would remain subject to the applicable criminal prohibitions of the CSA. I'm quoting in part there.
Yeah.
And so this isn't such a radical change. I mean, this is putting a substance from 1 to 3 so that it can be more adequately researched, both the harms and the benefits. And so many of the things that were suggested in the comments go to that point. They talk about, this would be so horrible for society. But it presupposes it actually legalizes cannabis, which it doesn't. And even for that argument, the claimed parade of horribles that occur after legalization simply don't occur.
No.
And we know this from legalization in other countries and states. So, from my personal perspective, I think the hearing is unnecessary. I'm not saying that from a political point of view. I'm not an expert on that. I'm not commenting on that. I'm saying from a substantive, legal, and scientific point of view, there really isn't a need for this additional testimony. We also don't know the basis for the DEA's decision to set the hearing.
Yes.
We're not sure which request, if any, was sufficient to state, that level of particularity about how the claimed interested party would be adversely affected or aggrieved by the proposed rule. And so that's an additional reason I think a hearing is unnecessary, because it's difficult to imagine who is directly and sufficiently affected or aggrieved, right? Like negatively, if adversely affected by a movement of marijuana as it's defined from 1 to 3, because it doesn't legalize do any of those things.
So then with everything that you just alluded to, I mean, Eric, with the OLC memo, with the certified accepted medical use that was found in the HHS report, and the FDA obviously being behind that as well, I mean, I don't want to get too speculative here, but is it safe to say that this hearing is theater? And I mean, we're going to hear arguments that are going to be allowed their day in court, but if you look at the data, you look at the science, and you look at the overall argument from the 3-letter agencies on the federal level, there really isn't a lot of concrete standing to go against the rescheduling in court.
So I think you raise an excellent point, which I hadn't addressed, which is sort of the other reason, right? Which is, why hold a hearing at all?
Correct.
I think in the government, it's a reasonable position to say we want to have as robust a record as possible prior to making this very historic decision. Mm-hmm. And while the change in status may not legally or factually lead to any of the negative things that are claimed, it's still good process to hold a hearing, since we're allowed to do that. And some of that just good governance, I would think.
Yeah.
Well, you make a good point. Like, I'd like to hear what the DEA's concerns are. When we have a 225-page document, we have over 40,000 comments, 92% are in favor, as many as 65% for descheduling. Whatever concerns they have, do you not think a lot of this narrative has been lost in translation as to what their concerns are and how this would be for society? This is purely about research. And if we're in a court of law, would that information not be pretty self-explanatory to, contest in a very sophisticated and accurate and fast way to say, would it not be addressed accordingly rather quickly?
I agree with you, and I hope so. And this is the point, right? I mean, this is not going to, most of the negative comments, let's just back up a sec. So as you pointed out, we have over 40,000 comments. Vast majority of them were in favor of rescheduling or descheduling. Like, some say you didn't go far enough, but that's certainly, those are not comments to keep it in Schedule 1. The comments to keep it in Schedule 1 are a minority and fairly narrow. And so some of them are anecdotal. And I don't mean in any way to diminish the tragedy that occurs in these families and the grief that folks go through. But many of them are like, my son started with marijuana and it ended in suicide.
Yeah.
And that's been research, and there are issues around that. And again, I don't mean to diminish that issue, but so many of the comments are of that, and those sort of get grouped together, right? And the fact of the matter is, a rescheduling from 1 to 3 has nothing to do with that. They're just simply saying, well, the harms are significant, and the FDA has already weighed that. You can keep saying it,
Yeah.
but it doesn't increase how it's valued, right? That has been weighed by the FDA as to whether marijuana, as it's defined in the Controlled Substances Act, has the risk of abuse and harms of a Schedule 1 or 2 drug, or more like a Schedule 3 drug. And so just having a hearing to say that over and over again, it's tragic, but it shouldn't change the record. Almost all the other comments are shadowboxing in the sense of saying, oh, well, this is basically talking about the harms of legalization, but this doesn't lead to legalization.
Yeah.
So they're talking about the wrong thing. And then we have the last thing I'll say and hand it back to you, the comments of, oh, you're just giving a leg up to the state legal companies. The comments saying, this is about giving a leg up to the state legal companies. It takes away 280E. It gives them a tax benefit. And that has nothing to do with rescheduling.
No.
That has nothing to do with any of the standards that the DEA or FDA use. If that's an issue, it's up to Congress. Congress can, I don't mean to give them ideas, but they can amend 280E to add Schedule 1, 2, or 3, right? I mean, that would take care of that issue. It's not appropriate for the DEA to refuse to reschedule because of some policy issue like that.
One of the main, I don't want to say drawbacks, or I guess negative points of this, is now it kind of pushes back timelines, something that we're used to in the cannabis industry by now, around regulatory shifts. Is there anything that you're advising clients on, or anything that you've kind of come to a conclusion on what a realistic timeline could look like now in this process?
So I think there's a broad range of realistic timelines. I'm going to give you a possibility, but I want to say I think it's possible, not likely at all, but I do think it's possible, particularly from my perspective, that the administrative law judge can complete the hearing in December.
Okay.
I don't think that's going to happen. I'm just saying that's possible, and they can be quick on issuing a rule. What's much more likely to happen is the hearing starts on December 2nd, but it continues into the new year. And I don't mean to say they're meeting every day because there are holidays, there are other things, the logistics, but in part because of that, the hearing continues into January or February 2025. I don't want to speculate too much about that, but that sort of timing puts us at an issuance of a final rule around a year from now.
Yeah.
Maybe it's going to be sooner, but I want to issue a word of caution to you and your audience. And I hate to say this, but it's just the reality. In the 1980s, we did a similar thing. I say we, I wasn't part of it. I was in college, but there was a petition, and there were hearings, and the hearing started in 1986 and went for 2 years. And so, that's within the realm of possibility here. I also want to point out,
how realistic is that 2 years? If you had to put a number on it, and I know, is it pretty realistic, Eric?
I would not put that as unrealistically speculative, meaning that should not happen.
Yeah.
That absolutely should not happen, in my opinion. I'm just saying there is precedent for that, and there's precedent for any hearing under any circumstance, judicially in the United States, here it's administratively, that it just takes a while, particularly when we're going to have to see how many parties become involved. I just wanted to point out as a point of history that back in that hearing, that resulted in the administrative law judge saying that cannabis should be rescheduled. Like back in 1986, the hearing started in front of administrative law judge Francis Young. Judge Young issued an opinion saying marijuana in its natural form is one of the safest therapeutic active substances known to man, and suggesting rescheduling. And the DEA administrator overruled that. It went to court in the case of Alliance for Cannabis Therapeutics versus DEA, and there was a ruling in 1994. So you're talking about it starts in 1986. There's a ruling in 1994 saying that the DEA administrator had not acted arbitrary and capriciously in overruling the ALJ.
So this has happened before.
So, I mean, that's like a worst case scenario that has happened. I mean, it's a worst case scenario that we actually have historical precedent for. I'm in no way suggesting I think that's going to happen here. I not in any way am I suggesting I think that's going to happen. I'm merely suggesting it's within the realm of possibility.
But there is historical precedent that an ALJ judge has actually granted merit to rescheduling cannabis, and the DEA administrator came out and said, no, we're simply not going to align with that ruling.
And I would, without impugning any individual involved in that, I would suggest that is the power, the trance of prohibition under which we've all been operating for many decades. And I think we're in a very, very different situation.
That's in the heart of the judgment.
In the 80s, folks thought, honestly, I don't know what I would have said if you asked me back in the 80s. I'm sure I would have said it probably should be legal. But I'm just saying the average person back then. If you ask the average person now,
it's completely different.
They would first of all be surprised that it's not legal. They're like, I can go buy it in my state. And then the second thing they would say is it certainly should be legal. Yeah. And then they'd say at least reschedule, right? I mean, this is not controversial.
Yeah, no. Agreed.
Is there any inference that you've made or anything that you've been talking to clients about as it relates to tax strategy in 2024? Because I mean, these pressed out time or these forecasted out timelines now, I'm assuming are going to have some sort of ramifications on their tax strategy for 2024 as it relates to 280E.
Absolutely. I'm glad that you raised that, and I had it in mind to answer your question, and I drifted off into another subject. It's a really important point. Obviously, we have the IRS has come out and said it's our view that 280E applies until cannabis is formally rescheduled. And that was in a notice posted that has, no weight of law, right? It hasn't gone through the proper administrative process. It's not a rule. It's just someone there stating their opinion, and we disagree with that. And we think it's a misreading of the rule. The rules talks about within the meaning of Schedule 1 or 2, and going back to what I just said, it's hard to find anyone who believes that marijuana actually remains within the meaning of Schedule 1 or 2. So when we look at the actual words of the statute, we come to certain opinions. I don't want to give legal opinions over your podcast, but we are advising clients that it's our position that they can take tax deductions sooner than that.
Okay.
And we are issuing opinions and disclosures to support that. Now, I don't want to go too deep into that in the podcast. I'm happy to talk to folks. I'm happy to take calls from prospective clients on that. But I mean, our view is that folks do not need to wait until the inevitable of what we go through all this and whatever we call it and however we characterize this, because clearly from all the activities and actions that have happened over the last decade, very few folks would find from the plain meaning of what Congress drafted, that marijuana, cannabis, remains within the meaning of Schedule 1 or 2. So I understand that folks have been very dejected by this. We're hoping for this positive impact of removal of 280E and basically what would be the equivalent of an infusion of capital into an industry that needs it very much. And my position is that we don't need to wait for that. That we should avail ourselves of that at this time.
Okay.
Now, it's a much more nuanced position than all of that,
Yeah.
but I would say that is a more hopeful situation than many people are considering at this point.
Look, I know you're tight for time, but I will say, I think it's worth noting that I think the way this has progressed, believe it or not, has been actually in a very fast manner for the most part. Would you not say, with regards to what's happened so far? Like, look, yes, we would have liked to have not had an ALJ hearing. However, it was highly likely that it could. You feel that it isn't necessarily warranted to have something like this, but saying all this, and what Anthony said earlier about there being a lot of political theater that's involved, and it's not easy to get everything lost in translation, but in a court of law with hardcore data and the amount of information, as I said earlier, I'll be interested to see how the judge views this, but most importantly, who's going to be involved in this hearing itself. So, like, what can we do as an industry to shed light on this? And more importantly, like, who are some of the people we can actually look at and assume that'll be part of this hearing?
So there's a lot there, and what I'm going to say is the most important part is some level of coordination. And I know it's always been difficult in this industry, but I think we're capable of it, and I think presenting in some appropriately coordinated manner could benefit everyone involved, right? I mean, it's not just a matter of advocacy in my view. It's a matter of us determining what is the right message, who are the right people, how does it get delivered, and doing that in some coordinated way so the ALJ could benefit. Like any joint defense would do that, right? You don't just like go off and do whatever you want and have you're trying to persuade someone at the end of the day. So I know that's kind of a cop out as to like who I think that should be. I mean, I think that should be me, right? I mean, and I'm sure lots of people sit there and say, I know the industry well enough. I'm persuasive. So I'm not going to pass judgment on that, other than to say I would urge the industry to have it coordinated in some manner. And I just want to say this in response to what you just said. This is all tremendously great progress. Yeah. I mean, when I started on this, closing in on 16 years ago, there were a few state programs that had legalized basically caregiver, right? And we're talking about providing safe, legal, and affordable access to cannabis and being able to harness the power of this plant for scientific and medical benefit. And yeah, in some ways it's slow progress and it's a slog. Yeah. But from another point of view, we have made amazing progress. I mean, it's breathtaking how much progress we've made, both in terms of actual legalization in the United States and internationally, advancement of the research of cannabis, and the change of the stigma and the public perception of cannabis. I think we've made tremendous progress. And I'm not just, blowing sunshine. I really do believe that. And I know we can all get down on, a curveball or waiting it out or anything like that. But I think it's, we're making good progress.
As I said, many I've spoken to in this industry in the past year says this has advanced actually a lot quicker than many people believe. Yes, it's not the greatest news about how this has to be delayed, but ultimately, I think you're looking at anywhere between, the new year, Q2, up until a year from now is something that realistically, if there's a final ruling that could take place, that's not unrealistic to think of a timeline like that. That's the big takeaway here, right?
Yeah, right. And in hindsight, I mean, it hurts now, but in hindsight, that timing won't be that big a deal.
Yeah.
So thank you very much. Thanks for taking the time to speak with me. I would like to tell you that I'm rushing off to a barbecue or hop in the pool or something like that. I have another call.
Yeah.
So,
Apologies.
so I wish you well, and I look forward, and thank you for having me on. I hope I have another opportunity.
You
to
will.
do
Yeah, it's good to catch up, Eric.
Thanks, Eric. Appreciate it.
Take care.
Bye-bye.
Bye-bye.
Hey everyone, thanks for watching our latest podcast. What'd you all think? Is there any information that we're missing? Is there anything you want us to cover? As these industries heat up, we're getting access to more and more big hosts. So let us know the questions that you want us to ask for you. As usual, smash that like button. We want this to go viral. Click on that bell for all notifications for the latest interviews that we're doing. And as usual, let's build this community. Subscribe to our channel because we appreciate it, because we wouldn't be here without you. Thanks for watching, everyone.